Hello, hello, dear participants, dear organizers. Can you hear me well?
Отлично слышно, Эркин.
Yes, we can hear you well, Erkin. Okay, thank you. So now I will share my screen, my presentation. All right, so hello once again. So within the framework of this specific webinar, I was kindly asked to provide some examples and to share how the international law, which was discussed by the previous speaker, how these international standards, how they're incorporated or embedded and implemented in practice in the Kyrgyz Republic. In fact, how the international law, so how exactly is it embedded, or what portion of our national legislation it occupies? So first of all will look at our constitutional provisions, or specifically Article 6 of the Constitution of the Kyrgyz Republic. In paragraph 3, it says that the widely recognized principles and norms of your national law, including your national treaties that came into force in accordance with the legislation of the Kyrgyz Republic, are an integral part of the legal system of the Kyrgyz Republic. That means that, and this is not just, well, from this word and from this statement, we can see that not only do your national treaties and laws that the Kyrgyzstan ratified are part of it, but also the widely recognized declarations, which are, let's say, guidelines, if you will, on human rights. They are also within our constitution, are part of an integral part of our legal system. And therefore, we can also see another sense, the procedure and the conditions for applying your national treaties and widely recognized principles and norms of their national law are prescribed by law. In Kyrgyzstan, we have a law in place. This is a law, you can see in here, a law on international agreements of the Kyrgyz Republic. And this law also sets forth or regulates starting from uh, Kyrgyzstan's accession to certain international agreements. So we have all kinds of ways of, signing, joining, acceding to ratification, and also it also regulates the implementation of international agreements and treaties, the issues of denunciation, and so on. So the law on international treaties of the Kyrgyz Republic, this is exactly the law or the procedure that we follow, that Kyrgyzstan follows in order to implement international agreements. So if we open this specific piece of legislation, we can see that in the preamble, once again, it says that the international treaties which came into force in accordance with the law, of which Kyrgyzstan is a participant, and also widely recognized norms of international law, are an integral part of our legal system, the legal system of the Kyrgyz Republic. Now, what does it mean, an integral part of the legal system? When we speak about the legal system, of course, we mean this is broader than just legislation. That also includes mechanisms of implementation of certain regulatory legal acts of the Kyrgyz Republic. And Article 31 of this law says that international agreements of the Kyrgyz Republic are subjected to full respect and compliance with by the Kyrgyz Republic in accordance with the international law and regulatory legal acts. So in our legislation, it says that since Kyrgyzstan voluntarily exceeds to, and also in accordance with the law, ratifies a certain international document, then Kyrgyzstan undertakes to fully comply with this treaty. And so what happens is, thus, at the legislative level, within our constitution, and secondly, within this law, Kyrgyzstan undertakes to, so those international agreements that Kyrgyzstan accedes to, they should be complied with and fully implemented. These norms should be fully complied with by Kyrgyzstan. We can also say when we talk about how exactly this is implemented, so one of the mechanisms would be bringing national legislation in line with your national norms. So if we look, for example, let's say the overwhelming majority of rights and freedoms, civil liberties, or standards on human rights, they are reflected in the regulatory legal acts in the Constitution of the Kyrgyz Republic. And the Constitution of the Kyrgyz Republic, Chapter 2, is fully dedicated to human rights, rights and freedoms. And it also declares certain standards. And they're also set forth and enshrined in international agreements. But in fact, when we think about what exactly do we mean, an integral part of the legal system, and we realize that what is meant here is that there are national norms, there are national agreements that Kyrgyzstan acceded to and ratified. They should have a chance to be implemented and to have a direct application. If we follow this logic, and this is how we understand constitutional norms, direct application means that a certain norm, a certain item or paragraph of a certain article in, let's say, the ICCPR, or it can be fully applied in a country without passing separate legislation for this. However, I would also like to discuss with you that by and large, like I said earlier, there are so many international standards that are fully reflected in all pieces of legislation. However, we see that there are some difficulties or challenges, or how can I put it? There are certain challenges or obstacles that our country is facing in order to fully comply with our obligations and commitments. Of these, like I said earlier, in our country, in practice, we do not have a direct application of international law, including in court proceedings, judicial proceedings. That means that in courts, you're not able to apply to court, let's say, with a complaint, and you cannot say that, hey, my international rights or the international law was violated.
Стандарта или нормы, закрепленных в
You have to refer to a specific right or freedom which is listed in the Kyrgyz legislation, certain thing, something that is set forth in our legislation.
практике, когда адвокаты
When we see in practice that defense attorneys, let's say in their when they speak in courts, they refer or they point the judicial system to the violation of certain international pieces of legislation. In practice,
это как бы на усмотрение суда.
so this is once again at court's discretion. I have experience of observing some trial proceedings, and based on my experience, I can say that international law and its norms.
Некоторыми судьями они как бы переносятся на решение
So
суда.
some judges do apply them, they do listen to it, but in some other cases, they're excluded.
Но сказать так, что, не знаю, в моей практике я еще не
In my
видел.
practice, I have not yet seen any single case when there would be a court decision or a court verdict that would be based purely and solely on your national law. So I will not say that this it never happened. I mean, I'm not the one to say it. In my practice, I haven't seen it. If some of you, maybe same in your practice, one of the participants, if you have a court verdict that is fully hinged upon your national law and its provisions, we'll be more than happy to see it. But once again, the practice that we have at the moment, the practice that we see at the moment, regrettably, your national law and its provisions, it does not have a direct application in practice in Kyrgyzstan. And the second thing, the second issue that, except for the direct application, that's the issue of legislation, which is not yet fully in line with international law. And so when we talk about the full compliance, that means that the standard, let's say a certain right or a liberty, which is set forth in the international document, it is identical with the standard described in our legislation in Kyrgyzstan. As an example, I can give the prohibition of torture, right? Freedom from torture, this is an absolute right, and it has the absolute prohibition. This is what it is in international law, and prohibition of torture is laid down in the International Covenant on Civil and Political Rights, ICCPR, and also torture is prohibited in our criminal code in Kyrgyzstan. However, the definition of torture, of what torture is within our national legislation, of what we understand by it, it is not, doesn't fully reflect the standard which is prescribed by the Convention Against Torture and cruel, inhuman, and degrading treatment or punishment. In particular, I can say that in the definition of a crime within our criminal code, there is no punishment for torture applied by third parties with the acquiescence or consent of public officials. Whenever it happens, it is difficult to apply. So within our national standard, this may not be interpreted as a crime, considered as a crime. So this is the second thing. So when we do have some difficulties in implementing our national standards and also applying them in our national practice, the third point is when we see that legislation contains norms. There are not so many of them, let's put it this way, but there are certain norms that are directly, they run counter to or counteract human rights and international law. In Kyrgyzstan, we have the government resolution, reference number 158, on the list of jobs and occupations and professions and positions with dangerous conditions where women are not allowed to work. So that is the resolution that basically restricts women in accessing about 380 jobs or occupations. And from the point of view of international law and standards which are enshrined in international law, this is discrimination against women on the gender discrimination. That is a discriminatory norm, and that is an example of direct inconsistency of our national norms with their national human rights norms. And regrettably, things like this, they also happen, and such pieces of legislation can also be found with respect to other standards. Now, the fourth point, which is worth considering, or the fourth aspect or challenge, if you will, in integrating international standards incorporating them in our national legislation and applying them. This is when in the Kyrgyz legislation, we have certain gaps with respect to human rights and freedoms. And this is one of the most outstanding examples that I would like to mention. This is the issue relating to one of the fundamental principles of human rights that is determined by each international treaty that the previous speaker discussed at length, that is the principle of equality and prohibition of discrimination. So in the Kyrgyz Republic, there is a legislative or legal gap, and we do not have the so-called all-encompassing anti-discriminatory legislation. So what do I mean by this? That means that the standards on equality and prohibition of discrimination in international law, it prescribes or sets forth types of discrimination, forms of discrimination, and principles on the basis of which a person may be discriminated against. The Kyrgyz legislation, so the problem is, on the one hand, we can see that the Constitution says everyone is equal before law, and everyone is equal, and all people are equal in Kyrgyzstan, and we have standards pertaining to gender equality. At the same time, legislation does not presuppose or does not talk about in what forms discrimination may occur. And most importantly, what we are missing in our legislation in Kyrgyzstan, that we don't have any mechanisms. Any mechanisms or any remedies or protection mechanisms against discrimination. In Kyrgyzstan, if you are a victim of discrimination, if you're subjected to discrimination, there is no legal remedy that would be effectively applied for you to go to court. And the court will not recognize this case because there is no legislative standard. And using the example of, well, you'll have to prove that discrimination occurred or it took place through alternative or relating documents. Let's say if a person is discriminated against from the point of view of accessing certain services, then right now, because due to a lack of an effective mechanism on protection against discrimination, so this can be circumvented, and they're trying to do this through the law on protection of the rights of consumers. But this is more of an alternative. That's because there is no direct standard, so you have to look for other alternatives. So without going deeper into details, I want to tell you that, in fact, the national legislation, it has some gaps. It has certain gaps with respect to implementing and exercising certain rights. And this is exactly what the previous speaker, Annalie, spoke about in her one of the last slides. She spoke about the state's commitments, right? When the state is committed to ensure and fully respect and protect human rights. And sometimes we can see that in the context of the Kyrgyz legislation, based on certain human rights, not all commitments of the state are clearly delineated or described. And as a result, either there is no legal remedy to protect certain rights, or there are no guarantees or safeguards, or there is no state's obligation to actively undertake measures to create all of the necessary conditions for every individual to exercise and enjoy their rights.